Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. This case is short, but the legal principle it established is enormous. Have you ever sent an offer and thought, if they don't reply, we have a deal? That assumption could cost you thousands in legal fees or lost property. Today, we're breaking down the landmark case of Felthouse v. Bindley to show you why silence can never bind a contract and how to protect your business agreements. To understand the law, we first need to look at the real-world problem that started it all. A simple family negotiation that went wrong. Paul Felthouse wanted to buy a horse from his nephew, John. After a dispute over the price, the uncle wrote a letter stating, "If I hear no more about him, I consider the horse mine at 30/15s. This is a classic example of an offer by silence, where one party tries to force a contract without a clear yes from the other side. The nephew never actually replied to that specific letter, though he intended to sell the horse to his uncle. He even told the auctioneer, Mr. Bindley, to keep that horse out of an upcoming sale. This shows that while one party might mentally agree, they haven't legally communicated that agreement to the offerer. Despite the instructions, the auctioneer, Bindley, accidentally sold the horse to someone else. The uncle then sued the auctioneer for conversion, claiming the horse was already his property. This is where the legal system had to decide, did a contract actually exist between the uncle and nephew at the moment of the auction? Now we get to the heart of the matter. The court had to decide if you can legally force someone into a contract just because they didn't say no. The court ruled that for a contract to be binding, the acceptance may want to be clearly communicated to the person making the offer. You can't impose a duty on someone else to reject an offer to avoid being bound by it. This protects people from being forced into unwanted obligations simply by ignoring a letter. The fundamental rule established here is that silence doesn't amount to acceptance. Even if the nephew intended to sell the horse, his failure to communicate that specifically to the uncle meant no contract was formed. In the eyes of the law, the horse still belonged to the nephew at the time of the auction. The uncle lost his case because he assumed ownership without a formal yes. People often overpay for legal disputes because they assume a deal is obvious based on a lack of disagreement. This case reminds us that until there's a clear outward sign of agreement, you're operating at your own risk. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. While this case involved a horse in 1862, the principles apply to every email, text, and contract you handle today. In modern commerce, we see negative option offers where a service continues unless you cancel. While consumer protection laws now regulate this, the core principle of Felthouse v. Bindley still prevents a random person from sending you a bill for a service you never explicitly agreed to. Always check for opt-out clauses in terms of service. In business-to-business deals, companies often send purchase orders with conflicting terms. If one side stays silent after receiving new terms, they might think the original deal stands. Felthouse teaches us that silence isn't a safe harbor. You may want to confirm which terms are actually accepted to avoid a breach of contract later. If you're involved in a high-value transaction where the other party is being vague or silent, don't just assume the deal is moving forward. This is the moment to consult a qualified legal professional to draft a formal acceptance. Relying on "we talked about it" can lead to expensive litigation that far outweighs the cost of a contract review. Let's wrap up with some safe first checks and decision frameworks you can use in your own professional life. The safest way to avoid a Felthouse scenario is to require a signature or a clear affirmative email. Never use language like, "if I don't hear back, we're good to go." It's legally flimsy and creates a red flag for the other party. Always push for a proactive confirmation of the terms. Be wary of quotes or proposals that include automatic acceptance, dates without your signature. If a provider tells you that your silence constitutes a binding agreement for a long-term commitment, that's a major red flag. Compare these quotes against pros who require a clear, signed work order. Sometimes, acceptance isn't a word, but an action, like a contractor showing up to work. However, Felthouse reminds us that even if someone intends to perform, the contract isn't solid until the communication is complete. Before spending money on materials or logistics, ensure the other party has acknowledged the agreement in a verifiable way. That's the practical version of what matters most in Felthouse v. Bindley. The big idea is to understand that silence isn't a safe way to form a contract. Always communicate clearly, get your agreements in writing, and avoid assuming that a lack of a no means you have a yes. If this breakdown helped you understand contract law a bit better, subscribe to Law Conquer for more case summaries and legal education. We're here to help you understand the rules so you can make smarter decisions. If this helped, please like the video too. If this helped, like the video and comment with the next case you want summarized. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.